Good morning, everybody, and welcome to today's webinar on the duty to prevent sexual harassment in the workplace. Thank you for joining us this morning. My name is Emma Ferdinando, and I'm an associate in the employment team here at FSP. I'm joined by my colleague Victoria Ounsworth, a solicitor in the team, who will be presenting alongside me today. I won't prolong the intro too much because I'm sure you want to get into all the interesting stuff. Just a few housekeeping points before we start. So you will see that you are all on mute, so we can't hear you. If you have any technical difficulties, the best thing to do is to put something in the chat box or in the question box, and we'll see if we can resolve that for you as quickly as we can today. The session is being recorded and will be sent to you over the next few days to all attendees, so hopefully you can join us for the full 45 minutes intended, but if you need to pop off somewhere, you will get a recording after, and obviously you can watch that at your leisure at a later time. We are aiming to have this session finished within the 45 minutes. Of course, that may somewhat depend on any questions that we get, but we're aiming to finish as close to that time as we possibly can today. And if you have any questions at all during the session on any of the topics that we're discussing, then please pop them in the question box and we'll endeavour to either look at them at the end, or if we don't have time to do that, then come back to you after the webinar with any answers to your questions that you may have. We will be doing an interactive poll just at the beginning of this webinar, just to gauge a little bit about what you're doing within your organisation relating to today's topic that we're discussing. So please do engage in the poll if you can, and we'll have a little chat about the results that we see. Slides and an information leaflet are in the handout section of today's webinar. But I think if you're not able to access them, we might be able to send them to you after the event as well, if you would like that. And your feedback on this session, of course, is hugely valued and appreciated to us, because we want to be providing you with content that you find useful and interesting. So your feedback is very much appreciated. You will be, a survey I think will appear at the end of the webinar for you to complete, but also it will be emailed to all participants after the event for you to complete. Those that complete it within the first 48 hours of the live session will be entered into a prize draw to win a £50 John Lewis voucher. So with one individual being chosen at random to win that. So if you could provide your feedback after, that'd be very much appreciated. So that's the housekeeping done. Now to move on to the more interesting stuff and the content of today's talk. So our intention today is to give you an overview of the new employer duty to prevent sexual harassment in the workplace. And this webinar is going to cover these following topics shown here on the slide. So first of all, we're going to have a reminder of what sexual harassment is. What does it mean when we say sexual harassment? And what do we mean when we use the term less favourable treatment? Because you'll see Victoria will talk about that term in her part of the talk today. So she will remind us on what sexual harassment is with some examples, taking us through the current position as it is under the Equality Act as of today. Then we'll have a brief reminder of the duty on employers to try and prevent sexual harassment in the workplace under the Equality Act. Then we're going to look at the consequences for an employer if they fail to comply with this new duty that's being placed upon them to prevent sexual harassment. What is changing? What is that new duty? How will it be enforced by either the tribunals or other sort of equality organisations? And then what can we do to help you? What should you be doing as an organisation, and how might we be able to help you with doing some of those things to be able to comply with that duty? So as I said, we're going to start first of all with a poll. So you'll see now appearing on your screen a question which says, as employers, do you currently have a sexual harassment policy in place? And you've got yes, no, or a form of anti-harassment policy, but not specific to sexual harassment. So if I could ask you all, please, to place your votes. I'll just give you a couple of minutes to do that. And then we'll have a look at the results. Oh, so there we go. Results coming in. So 39% of you do have a policy, 10% don't, and 51% have a general anti-harassment policy, but not a policy which is specific to sexual harassment only. Obviously, a general anti-harassment policy will include all the different types of protected characteristics which you shouldn't harass people for. So interesting. You'll see probably as we go through this talk that we would perhaps suggest having a standalone policy that covers that, but we will see. So thank you very much for participating in the poll. I'm now going to pass on to Victoria to get us started on the main content of the webinar. Thank you.
Thank you, Emma. Good morning, everyone. Thank you so much for joining us this morning for our webinar. So before we look at the new duty, we thought it might be useful just to summarise the existing position in respect of sexual harassment as it stands under the Equality Act. So firstly, what is it? So you'll see section 26 there of the Equality Act expressly prohibits 3 types of harassment. So the first one, harassment related to a protected characteristic, so sex, age, race. The second, sexual harassment specifically. And the third, the less favourable treatment, where an employee rejects or submits to unwanted conduct of a sexual nature, or that is related to gender reassignment or sex. So for the purposes of this webinar, we will be focusing on 2 and 3. So sexual harassment, when does it happen and when does it occur? So sexual harassment occurs when A, engages in unwanted conduct of a sexual nature. The key here is being unwanted, and that conduct has the purpose or effect of either violating B's dignity or creating an intimidating, hostile, degrading, humiliating or offensive environment for B. So for clarity, the current EHRC, so that's the Equality and Human Rights Commission, code describes unwanted conduct as any conduct of a sexual nature. So that can be verbal, non-verbal or physical contact or conduct, and as it stands, a single incident is enough to constitute harassment. So whilst the legislation doesn't give any specific examples of what unwanted conduct of a sexual nature might mean, the guidance that we have from the EHRC does give a list of examples, and I've listed just a few of them here on the slide. So we have sexual comments, spreading rumours, displaying sexually graphic pictures, unwelcome touching, or making propositions to colleagues. So we'll move on to the next slide then. So here we're going to look at when does less favourable treatment for rejecting or submitting to harassment occur. So as for the third limb we've just spoken about, it's the less favourable treatment. So this is set out in section 26(3) of the Equality Act, which is set out in the slide here. So we've got where A or another person engages in either unwanted conduct of a sexual nature or unwanted conduct that is related to gender reassignment or sex. That conduct then has the purpose or effect of violating B's dignity or creating an intimidating, hostile, degrading, humiliating or offensive environment for B. And because of their rejection of or submission to that conduct, A treats B less favourably than A would treat them if they had not rejected or submitted to that conduct. So in summary, if an employee rejects or submits to the conduct and is subsequently treated less favourably than they would have been if they had not rejected or submitted to that conduct, then this section of the Equality Act would be satisfied. So an example of this would be where, for example, a senior manager makes a sexual proposition to their secretary. The secretary then rejects the manager's advances and the secretary is subsequently not invited to the office Christmas party or any other social events that might take place. The secretary then believes this is because she rejected her manager's proposition. Now, in this case, the secretary may then look to bring a claim for harassment. And of course, this is just one example. I mean, unfavourable treatment can present itself in many forms, and of course, as we mentioned earlier, it can be a one-off event or an ongoing course of conduct. Now, it should be noted that obviously less favourable treatment can also occur where the reason for the less favourable treatment relates to an employee's rejection or the submission to harassment from a third party. So here we're talking about customers, agency workers or contractors, for example. So some of you may recall there were plans to amend the Equality Act to reintroduce employer liability for the sexual harassment of employees by third parties, amongst other things. And obviously that was originally repealed in 2013, but obviously that reintroduction did not take place, didn't proceed. But the suggestion remains that obviously employers should at least consider the risks that are posed to their employees by third parties alongside their other internal measures, as there is felt to be a chance that the new reasonable steps obligation that we're going to consider shortly in some way could extend to those third parties. And obviously the ECHR code has various recommendations in this regard as well. But on the flip side, it's just worth remembering that whilst employers should be taking reasonable steps to ensure that their employees do not harass any third parties that they may come into contact with, and obviously noting that a harassment claim could be brought against the employer in its capacity as a service provider, regardless of whether the employer knew or approved of that act that's been complained of. So it's quite an important thing just to bear in mind. But on to the next slide, we'll look at the current position under the Equality Act. Now, where an individual feels that they may have been subject to sexual harassment or less favourable treatment, as we've just considered at work, then that individual can bring a claim in the Employment Tribunal. They may also be able to bring separate claims against their employer or their harasser under the Protection from Harassment Act, or a claim for personal injury. But obviously, for the purposes of this webinar, we will just be focusing on claims that an employee can bring in the Employment Tribunal under the Equality Act. So currently, there is no positive or mandatory duty on an employer to prevent sexual harassment in the workplace. However, as we've got here on the slide, section 1091, employers are primarily responsible for sexual harassment committed by their employees during the course of their employment. So it is just important to note that the liability can apply regardless of whether or not the employer has approved of or even are aware of their employees' actions. So we're just going to look at the reasonable steps defence there on the slide as set out in section 1094. So obviously this defence exists where the employer is able to demonstrate that it took all reasonable steps to prevent the harassment, and we call it as the reasonable steps defence. So where an employer can show it took all reasonable steps to prevent an employee from harassing another, then it may be able to escape liability for sexual harassment. So some examples of these steps would include having specific policies in place, such as a sexual harassment policy we considered in the poll earlier, which are communicated to employees and that obviously provide for some form of reporting procedure where employees are able to report such instances. Reasonable steps can also include providing training to managers and staff in harassment issues that might arise, or in dealing with complaints of sexual harassment more specifically. So with this in mind, it has always been important for employers to take appropriate steps to prevent sexual harassment in the workplace, despite not being legally required to do so. But we'll have a look now at some of the consequences of failing to prevent sexual harassment in the workplace, which we'll move on to the next slide for. So here we can look at some of the consequences of that failure, both from a legal perspective and a business one. And you can see on the slide there, we've set out a few examples. So obviously the first one, costly litigation and settlement discussions. So as with many other types of litigation, the cost of defending sexual harassment claims and negotiating settlements can be very high indeed. And obviously if an employer were to be unsuccessful in defending a claim of this nature, then the claimant could be awarded compensation for financial loss, injury to feelings, amongst other things. Then we've got there the loss of highly skilled and valued employees. So this typically occurs where complaints of sexual harassment are not dealt with or taken seriously. We've got damage to reputation. So sexual harassment cases can be quite high profile, particularly where it involves very senior members of staff in an organisation and where matters and obviously subsequently proceed to tribunal. The outcome and details will often become a matter of public knowledge following judgments being published. One example of this kind of publicity you may recall recently in November 2023, where hundreds of McDonald's employees made complaints of sexual assault and harassment committed by them by their colleagues and superiors. Obviously these allegations were heavily publicised in mainstream news, and obviously a subsequent BBC investigation took place which was heavily publicised too. We've also got culture. So allegations of sexual harassment amongst staff can create a negative culture within the business, and it can create a culture of fear and mistrust where employees feel like they can't raise issues. It can also lead to problems with recruitment and retention of new staff. And obviously with the prevalence of social media, employees have access to more and more information. And obviously we also have websites such as Glassdoor, where employees can read about other employee experiences also. We've got there damage to the value of the business. So obviously not only can it affect a reputation as an employer, it can have a detrimental effect on the way your customers and your suppliers view business. There have been many headlines in recent years, but one key example that sort of springs to mind was back in December 2018, where we saw Ted Baker's share price drop by more than 13% after it became public knowledge that they were investigating complaints of inappropriate behaviour by its CEO and co-founder. So it's quite a significant drop there. And we've also got other consequences, in particular for regulated employers. So obviously where sexual harassment issues can have regulatory consequences, for example, those in the financial services industry. So moving on to the next slide then. So what is changing? So obviously this is the key thing we're considering today on our webinar. So obviously the now previous government committed to introducing a mandatory duty on employers to prevent sexual harassment, which was formalised in the Worker Protection Amendment of Equality Act 2010, Act 2023, which is coming into effect on the 26th of October this year. So the purpose of this act then is to introduce a new mandatory duty on employers to take reasonable steps to prevent the sexual harassment of their employees. The act will also give employment tribunals the power to uplift sexual harassment compensation by up to 25% where an employer is found to have breached this new duty to prevent sexual harassment. So under the new legislation, obviously there will be a positive and mandatory duty to take those reasonable steps to prevent sexual harassment of their employees. So it will require employees to take a more proactive approach in dealing with sexual harassment in the workplace. So when the bill was first proposed, it was originally drafted to include a reference to all reasonable steps. So instead of reasonable steps, it was drafted as all reasonable steps. However, that was subsequently reduced to what we see now, the reasonable steps in the House of Lords, as there was some comments and concerns that the reference to all was significantly more onerous on employers. So then we saw then the revised drafting, which was considered more appropriate and proportionate. So now you may be asking, what is reasonable steps? You know, what are those steps we need to be taking? So the technical guidance that we currently have, the EHRC code, are due to be updated to reflect this new duty ahead of it coming into force in October. They are hoping to publish the revised guidance in September, so we can expect it to come in and for us to have a look at it before the new duty comes into force. We don't know yet what it's going to look like. Consultation on it has just commenced, and that will be closing on the 6th of August. So we can imagine something to come out relatively quickly after that time. However, what we can say is that it is likely that the reasonable steps an employer is going to be required to take will ultimately depend on the size of their employer's business, the industry in which they operate, and these measures will likely include various steps such as training or ensuring sufficient policies are in place. There will also be penalties for a failure to comply with this new mandatory duty, and I'll now pass you over to my colleague Emma, who will obviously consider some of those measures that employers can take and explain those penalties in a bit more detail. Over to you.
Thank you, Victoria. Thank you. So as Victoria's already mentioned, the new duty places a mandatory duty on employers to prevent sexual harassment in the workplace. And although the duty imposed by the 2023 Act is less onerous than originally envisaged, because it doesn't cover the sort of the third-party claims that we thought it initially would, it is still very significant. The Act aims to move the position, I'd say, from a culture of redress. So previously it was, a claim has happened, what can we do to, do something about it after the event, to now more of one of prevention, requiring employers to take a more proactive step to tackling toxic environments within their workplace and environments where sexual harassment may occur. So the new duty, as we see here on the slide, doesn't create a standalone claim that employees can bring in employment tribunals. Rather, claims for the breach of the new duty can only be considered by an employment tribunal where an employee's claim for sexual harassment has been upheld. So as usual, now an individual will bring their claims at the employment tribunal, say for unfair dismissal and or sexual harassment, and they will need to go through that process and win that claim and have the tribunal say this individual was sexually harassed. And then if that finding is made, the employment tribunal will be required to consider whether the employer breached its duty, this new mandatory duty upon them, to take reasonable steps to prevent that sexual harassment from happening. And if they conclude that the employer did not take all reasonable steps and did not comply with that duty, then they do have the power to apply an uplift to any award of compensation made in relation to that sexual harassment claim by up to 25%. So obviously, very big numbers. Compensation in sexual harassment claims could already be very high because of the nature of the allegations and the injury to feelings that it results in, but a further 25% uplift could be applied if the employer failed to comply with its duty to prevent that. In addition, the 2023 Act also gives the Equality and Human Rights Commission, what I would call sort of Britain's equality watchdog in some ways, the power to enforce this new duty as well, because it's all well and good. An individual goes to the tribunal, they're found to have been sexually harassed, they get their compensation and they get an uplift, and that may prevent, it may concentrate the mind of that employer to do something about it going forward. But what about the bigger picture? And obviously what they're trying to create by this legislation is a culture of moving away from toxic work environments that we've seen a lot about in the press recently. So the EHRC also have enforcement duties, and they include powers such as the right to conduct investigations when it suspects that a person has committed an unlawful act, enter into binding agreements with people or organisations in order to address ongoing issues of discrimination or harassment. And that may be, in particular industries where it's quite prevalent, in particular types of work where it's quite prevalent. That may be of course very useful both for employees, so they have that protection, but also for employers if they don't really know how to address the issues that they're having in the particular sector in which they work. That could work in their favour going forward, and to assist or intervene in certain disputes as well. So certainly we'll see how the EHRC's enforcement plays out. As Victoria already said, they are the ones responsible for writing the guidance. That's currently in a consultation process, and we'll see what happens in respect of that before the duty comes in October. But obviously, they have in the past, in recent years, taken action against large companies who have failed to properly address issues of sexual harassment in the workplace, and I certainly don't see that they won't be shy in coming forward and doing that again, probably even more strongly once this new duty is in place, and making sure that employers are doing what they should in respect of that. Obviously now we are under a new government. Just a brief note here in that I believe it was in Labour's manifesto, they did state they'd be looking to strengthen protections for whistleblowers, including updating protections for women who report sexual harassment as well. So it's not just thinking about claims that may be brought under the Equality Act for sexual harassment, but how does that play in with whistleblowing and the crossover between that, and that may be particularly prevalent depending as well in the industries in which some of your businesses operate. So I suppose that's the scary stuff, in that this is the new duty, this is what you need to comply with, and if you don't, this is what could happen. So I'm sure now you're all wondering, well, what should we be doing about it now, if anything? And I'm going to cover that now on the next slide. Some practical suggestions really about what you should be doing now, if anything at all. And obviously our advice is you should be doing something. So from the previous sections of the webinar, hopefully you've seen why you should be taking active or preemptive steps to ensure your compliance with the duty. This duty isn't about sitting back and waiting for things to happen in the hope that you will be able to rely upon what you already have in place. And I appreciate lots of you as organisations will already have, as we've seen in the poll, some form of anti-harassment policy in place. But is that going to be enough to comply with the new duty? So unless you are very proactive in this area of sexual harassment, it's something that's been on your sort of HR radar and top of your agenda, and perhaps top of the agenda of the directors of your company or those on the board of your company, and coming from up high, then unless you provide regular training updates to your employees and regularly update your policies, then it may be unlikely that you're going to be able to demonstrate you have taken all reasonable steps to prevent sexual harassment if you want to simply rely on what it is that you already have in place. So no matter how up to date you consider your anti-harassment and bullying policies to be, there is always plenty to be doing. And I think the first starting point is going to be considering your why. You know, why as a business is this important to you? And Victoria already mentioned earlier on in the talk, you know, the commercial implications of having to deal with claims for sexual harassment, and we of course all appreciate that. But also, what about, you know, it's about protecting your employees, making the workplace a nice environment to work, creating a culture that's inclusive, protective, and with strong values. And you need to be thinking about, are your sexual harassment initiatives coming from high up in the business to demonstrate they're being taken seriously by the company? Or are you just updating a policy and through HR and putting on the internet with not much publicity coming from those at the top? If they can see the messages, we are inclusive, we've got this open door policy, you can come and talk to us about everything, this is going to help employees feel that their concerns will be taken seriously and make them more inclined to speak up. So your why should include an assessment, really, I think, of the culture of your business as a whole. Is your organisation a place where people feel they can speak up? Will they be listened to and taken seriously? Do people feel they can be honest about issues they've witnessed or been subjected to? And this also works the other way around. You know, if someone, perhaps they are the person that has made the mistake or potentially harassed someone, said something inappropriate at the Christmas party, or for an example, do they feel actually comfortable in coming forward and reporting their wrongdoing to you on their own behalf? Because I think, you know, having that open dialogue both ways will mean that issues will come to light earlier and therefore can be resolved earlier, or at least in some circumstances. Next, we consider a good place to start would be carrying out a risk assessment of your business and the particular areas and the industries in which you work and the ways in which you work, your working practices. Are there particular areas of your business that pose a greater risk of sexual harassment occurring? You know, do you have lots of staff out attending business development events where there's lots of alcohol consumed? Do staff engage with members of the public? Do staff work in small groups, perhaps one-on-one, where the opportunities for sexual harassment may be greater? So it's thinking about those things and then running a risk assessment about which areas of your business may be high risk, medium risk, or low risk to the chance of sexual harassment happening. So it's really just applying your mind to your business and working practices and running that risk assessment so you can see where the holes may be. And then alongside that, a comprehensive review of your existing policies and procedures. What do your existing policies say about sexual harassment specifically? Do you have a standalone sexual harassment policy? Should you have that? And are references to harassment in your other policies referring to sexual harassment as well? Because what those policies need to do, you know, without clear policies, people may struggle to know, am I being sexually harassed? And if I am, what do I do about it? Those policies can make it really much easier for individuals to know, if I feel I'm being harassed, how do I report it? Am I going to be protected? Will my information be kept confidential? Will discretion be applied? So those very clear policies, and that's really going to be your starting point, I think, as well, if unfortunately you find yourself on the receiving end of a sexual harassment claim. Your starting point is going to be, well, we had these policies, we told our employees about these policies, so they should have known they could have reported it, and or our employees should have known that we don't tolerate sexual harassment, and this is what we consider sexual harassment to be in respect of the perpetrators. So it will work both ways there. But again, it's about creating a culture of comfortableness that people can speak up, and having that policy to refer to, telling them who they can go to speak to is going to be a starting point for many employees. The next is training, because of course you could have all these policies in place, but are people actually reading them? I mean, yes, they're put on your intranet, they're in your handbook, they're given to new starters, they're told to sign a document to say that they've looked at them and read them, but how much have they actually absorbed that information? And 9 times out of 10, people absorb information much more when it's put to them more in a training environment that's engaging. So what training are you giving to your employees about what sexual harassment is and what the company's position is on sexual harassment in the workplace, both from it's not tolerated, and if it does happen to you, we're going to be here to support you, and this is what we'll do about it. So you need to look at how regularly you do that training. What does it include, and who is it given to? And are you giving different types of training to managers, for example? Because it may be managers that receive the reports of sexual harassment. It may be those that have to investigate it alongside their HR colleagues. Do they know what they're doing? Do they appreciate the sensitivity of what's being put to them? So training is very, very key. And again, keeping records of the training that you're giving to your staff, because that will formulate part of your defence to any tribunal claim. What reasonable steps did you take? Well, we had this policy in place, and we trained all our managers and we trained all our staff, and we regularly do that, and these are the records to show when that training was done and how regularly it was updated. Again, it's about having that paper trail to show that you have taken steps to prevent it in the workplace. And then there's some other practical considerations. So the above measures, if the above measures have the desired outcome, then you may find yourself receiving more reports of sexual harassment because people maybe feel more able to do so, more open to doing so. But how will you manage that within your organisation? What support will you give those that make allegations and those that are accused? Do you have, for example, mental health first aiders or particular people trained within your HR team that can support on both sides of that internal sort of grievance and or disciplinary process? Because it's not going to be a nice process for either of those individuals. So is there support internally, or are there external resources that you're signposting your staff to in respect of that? And what about those that investigate the allegations? Firstly, do they know what they're doing? Are they specifically trained in being able to deal with disciplinaries and grievances on that topic? And that's where your training offering comes in. But also, what support are you giving those managers if they are having to deal with disciplinaries and grievances on that topic? That may be uncomfortable for them to do, and they may need some support even though they're not directly involved in the issue itself, and they would probably want some support in going through that. And we would also just suggest considering whether or not the measures are working. So you may put in place some of the measures that we have suggested, and they were just recommendations. And of course, what you do for your business will be very dependent on probably what comes out of a risk assessment that we would suggest that you do. But are they working? Do they need to be tweaked? Are people coming forward? Are people content with what they can do, or are they being supported in the way that they need to be? And the best way to do this may be through a staff questionnaire or by way of an employee forum, asking for specific feedback on some of the recent developments that have been made in sexual harassment policies and processes within your organisation. Depending on your type of organisation and the size of it, do you want to appoint what we would call, sexual harassment reps, individuals that, sort of take charge of that, pushing through the initiatives in relation to that, and individuals that people can go to and see how those things move, through the business and whether or not they are working. I appreciate it, this will all depend on the size of your organisation, the size of your workforce, but it's all a way of applying your mind and assessing whether what you have done has had a positive effect, because there's no point doing all of these things if it's not having the desired outcome, which is a more open, inclusive culture that ultimately reduces the chances of sexual harassment happening within the workplace. So they were all the suggestions. These aren't a list of the steps you must take. What needs to be done in your specific organisation will depend on your industry and its particular risk factors, but we would certainly suggest that some of these steps are taken to be able to demonstrate that you have taken reasonable steps. So moving on next, how can we help you? So I suppose, first of all, a question, are you confident that you will be able to demonstrate that you have taken reasonable steps to prevent sexual harassment of your employees? You as a business may not be able to answer this question confidently until you have undertaken some of the steps that we recommended above. So until you've carried out perhaps some form of risk assessment and a review of your policies and the culture within your business, you may not be able to confidently answer this, because as I'm sure you now appreciate, it goes much further than, do we have an anti-harassment and bullying policy, or do we have a anti-sexual harassment policy within our business? It goes much further than that, and there's much more of a requirement on you to do more than that. So how we can help you is through, we've put together a package called Sexual Harassment Prevention Legal Review. And this is something that we can provide to you. And what we do is some of the things that we'd mentioned above in my previous slide, which is conduct a risk assessment of your business via a smart online questionnaire. And that will be a series of questions that you can complete on particular working practices within your business. And that will feed answers back to us, and we will review those answers alongside a review of your equal opportunities and anti-harassment policies. So all of those that you may have in your organisation that are relevant. That may be your anti-harassment, your bullying, maybe your whistleblowing policy, maybe your IT policy, and things like that may feed into sexual harassment and other forms of harassment as well. And then following that, we will produce a bespoke report with recommendations for your business, covering both legal requirements and practical suggestions. And there's details of this in the leaflet in the handout section of this webinar. And obviously, if you'd like more assistance from us in relation, or more information from us in relation to this package that we offer, then please do not hesitate to get in touch. But the purpose of the review as a whole, it's an exercise to get a clear understanding of how things stand within your organisation presently and identify any gaps in your internal policies and processes. The report will then make recommendations on where improvements could or should be made, and then obviously it's depending on the risks associated, and then it's really up to you as to which of those you implement from the suggestions in the report. And there may be a lot, and there may be very few, depending on what your current position is. We will also be producing a training offering for employers and specifically for managers. And if you want further details about that, then of course reach out to us and we can provide them on request. I think training is going to be very much dependent on where are your key areas of risks, and what in particular do you need our help with. So now moving on to the next slide, which I think we've got some time for some questions. So Victoria and I have given you a lot of information on the sexual harassment duty, and I think we have some questions that have come in. So I think I'm going to start by asking Victoria a question, and then we might do one or the other each. So Victoria, we've got one here that says, what is the position in situations where employees are harassed by third parties?
Yeah. Okay, so obviously we touched on it briefly, the previous proposals, but I mean, currently there is little redress for employees at the moment who are harassed by third parties during the course of their employment. Reason being is obviously we used to have those provisions in the Equality Act, which we touched on earlier, which obviously where employers were liable for harassment of third parties in certain circumstances, but obviously this was repealed. And all we have really is case law would suggest that employers are only liable in very limited circumstances under that section 26 we looked at the beginning. And obviously, while there was some talk of bringing this provision back, for now it hasn't made its way formally into any kind of provision. There was some suggestion when they were debating the new amendments about looking at this duty to, obviously, the reasonable steps duty to prevent sexual harassment, and the fact it could extend to taking steps to prevent sexual harassment by third parties. But obviously, as we see it at the moment, that position is currently unclear. And I think really for employers, I mean, on that basis, we should probably be erring on the side of caution when drafting policies and training staff as to the risks posed by third parties, particularly given, the employer's other general duties, taking in those other duties generally that employers have to their employees, like, providing a suitable working environment, the mutual trust and confidence. So with those other duties in mind, I think, really erring on the side of caution, making sure people are aware of those risks, training them is probably a good step to take.
Thank you.
You're welcome. Let's have a look. Okay, so we've got a question here. When can we expect to see the new EHRC technical guidance?
Thank you. So as Victoria mentioned earlier, it's currently in consultation with the EHRC. I think the closing is the 6th of August, you said, in relation to that. So it needs to be before the duty comes in at the end of October. We don't know when the guidance is going to be coming out. We would like to think it will perhaps be, I don't know, sometime the end of September, but we don't know. The consultation closes on the 6th of August. They have until the end of October. So sometime in the middle of that will be the new guidance will be published ahead of the new duty. We will post an update when we have any further information. There'll probably be some update on our LinkedIn or our website or an article on the same. So I would suggest perhaps just keep an eye on that, and we'll let you know as soon as we know.
Thanks, Emma.
Thank you. Right, more. Is it a requirement to carry out a risk assessment?
So obviously, Emma, you touched on this bit quite a bit in your discussion there earlier. So not specifically, there is no specific requirement to carry out a risk assessment. The duty is obviously to take reasonable steps to prevent sexual harassment of the employees. And a risk assessment, obviously, Emma, you gave as an example of one of those reasonable steps that can be taken. Perhaps particularly in businesses that operate in sectors where there is a higher risk that sexual harassment might occur. And obviously, as you said earlier, Emma, think about your business and think about those specific risks that are posed to your employees. Perhaps consider where there's a power imbalance, more senior management and lower level staff. Consider workers in the care industry, retail, hospitality, those who are more likely to come into contact with third parties, or where they work alone. So workers who are attending people's homes, working in shops alone, things like that, or in the office on their own. So just considering the specific risks posed to your business and conducting appropriate risk assessments off the back.
Thank you. I think maybe we've got time for one more brief question, and I'll try and make my answer brief.
I think we've got one here. This is okay. This slightly shorter one. So, what should staff training cover?
Okay. So I mentioned earlier, I think a key part of showing that you've complied with the duty is training. What it will cover, as I said, will very much depend on your industry, but I think it needs to be an overview. Remind employees of what sexual harassment is and what they shouldn't be doing. This is what the conduct is, and this is what we expect you not to do. So remind them what they should not be doing. How, if they experience it, what you're going to do about it, the support they're going to receive, who they should report it to, so that they know exactly what to do and where they stand, so that they can feel comfortable in reporting it. How managers should handle the complaints. So there should certainly be sort of some specific training for managers, we would say, on how they deal with those complaints. Reminding them of the company approach on equality, diversity and inclusion, so that people feel part of included in that group, and that they can speak up. And then the roles and the responsibilities of employees in ensuring policies are effective. So, this, as an employee of our business, this is upon you to ensure that you don't sexually harass people in the workplace, putting some duty on them as individuals of the business that we're expecting you to comply with this and the standards of the behaviour we expect your employees to have. So I think we've run out of time for questions, I'm afraid. Just a few closing points from us today, and then we'll let you get on with your morning. So as I've already said, there is a flyer in the handout section, and that will be emailed to you following the recording of the legal prevention review that we can do for you, the risk assessment, the review of policies, and producing that report, which you can then use as your tool to implement within your business any changes that we may recommend in order to try and assist you in complying with the duty that's being put upon you by the new sexual harassment duty. One final reminder from us is to please fill in the feedback form. We really, really appreciate your feedback on how we did today, how anything can be improved, what you'd like us to talk about in the future. And as I said, there is a £50 John Lewis voucher to be won if you complete the feedback within 48 hours. So good luck on that one. And of course, we're always doing webinars. We're always producing articles and content on our website, not just us as the employment team, but also our colleagues in the immigration team. So please, if you want to sign up to our newsletters, you can do so. You can let us know on the feedback form. You can follow us on our LinkedIn or our other social media sites. We're always running regular webinars, articles, etc. And we run regular networking forums for HR professionals as well. So finally, just a big thanks from Victoria and I for attending. We hope you found it interesting and helpful. And if there's anything you didn't get the chance to ask during the session today, or anything we can help you with going forward, then please get in touch. And we hope to see you all at another event soon. Thank you.
Thank you very much. Thanks.